I was just recently asked by a commenter on one of my videos of what my thoughts are on the work of Mark-krishon Christopher. Now, I have run across this gentleman in different news feeds and articles and obviously videos shared through the works of David-Miller. And there is, I mean, when I first heard it, it seems to warrant some attention based on the proper syntax grammar. But to be honest, I never did much investigation into it because as I began to learn what law was, it is written as it is written. So for me to speak to it would be in the same context that is used by courts of judicial independence and courts of inherent jurisdiction. So would it be any effort to should I spend any effort in learning proper syntax grammar when I'm not going to be using it to affect my right to settle that legal estate that's held currently in right of the monarchy? And the answer is no. And it only came to that realization, of course, when I started to comprehend what law is. Now, his work, well, I'm not going to really critique it because the first question should be asked of you before, now that you're learning essentially what law is essentially what is this man who you are listening to or doing research in conjunct with and going through his webpage, does he know what law is? Is he speaking law? And the answer is no. He doesn't speak to law at all. He's speaking to redemption processes within his comprehension of what that means or what it will do within the system that is regulated under banks and the second level use to land. Well, let's stay with the law. Who are regulated under the second level of use to land through equity under a trust instrument. So that's what he's doing. He's looking for means in which to intercourse within that realm. We are not. Well, you may be. I mean, again, that's up to you. But my interest is to fully settle that legal estate created at birth. And as such, when that's fully settled as settler and it's vested fully within me, that dissolves the trust and relationship of trustees, and now I have full and utter power. There is nothing higher than I am when I settle that interest. And additionally, no longer am I subject to perform any obligations in English law. So he has stated that he's a global, yeah, he's got hyphen through each word. I guess that's the proper syntax grammar. I'm not going to read it that way, but the Global-Chief-Federal-Postal-Court-Judge and Plenipotentiary-Judge, copyright, copy claim. Now, even those words, copyright, copy claim, well, we're dealing with commerce. We're not dealing with law. He's dealing with inequity. So everything that he's sharing, the papers I looked at, the documents that he shares, to me, based on the law, are totally worthless. Okay? How they affect remedy within the system? Well, I don't know if you're sending some judge into some tailspin of not comprehending what you're saying, especially the lower courts, and definitely any of the compulsory agents, being police officers, may be set back by it and said, you know what, I'm not going to even deal with it. But if you're setting off mortgages and debts and that kind of thing within the system, then that's only going to extend to the relative nature of that system itself, and that system is under trust for sale, means that every mortgage and every debt is is a shared responsibility whereby nobody is an absolute owner. They are assumed owners within the system. So you're setting off a setting off a debt formally that is just going to be transferred to others within the same system. And what is um, the foundational principle of monopolies? To bankrupt your neighbor. That's how you win. So what are we doing here? In fact, the documents he shares with, including um, the document concerning the Philippine as being the king, more or less, I guess, the primary one individual where all things then stem from, and is again a matter of jewelry, right? You remember when we spoke about that in other videos where jewelry was never seen in the common law, can't be seen in common law because those people within that agreement cannot purchase or be with rights in the common law, because common law had to deal with an individual interest through a life that then at a point established a fee, which was a service in allegiance to the crown. It was personal. The Jew couldn't do that. They were bankers. Same with the Catholic Church, to which it's just another form of jewelry, right? You're under the Judeo-Christian God, um, which in essence, it's through that vehicle of the Roman Catholic Church and Christianity that allows the Jews to use or to charge the concept of usury and interest, because they have a whole different system. They don't want to hold their own race within the confines of debt and interest. So I think they have a jubilee set every 7 years and they settle everything. So all that's happening, if you're dealing with any perpetuity instrument, you're dealing with any government, any bank, any king, any of those matters, especially kings that are not established under English common law, or that I know of, I don't see any reference to how they're associated, and that doesn't, I'm not really concerned of, delving down into that rabbit hole to see where that king in the Philippines receives his right and his power, because I have no interest. I only have interest in that matter that settled in the monarchy, the title, my legal estate, to which that who holds that interest as a legal personage is the one that I have a direct agreement with only through operation of law, not through an act of parties. I didn't express anything, and tacitly is not generally a act of parties unless we're dealing with within the confines of equity, such as if you're sitting down at a restaurant and you are ordering from the menu, it is implied tacitly that you've accepted all the terms and so forth when you fed the food, and such that you're going to pay for it. Um, that is how, expressly, that it could be measured within equity, that's how it's seen. You're tacitly agreeing. You've never made your intent known, because your full intent would have to be realized, of course, in the common law, the English common law. So that's my spin on Mark-krishon, Christopher. That's all, you know, I don't know. It's just, I guess, uh, creating the agreement within the system itself. And do you really want that? That's what you need to ask. If you want to continue in the system and you don't really want to embark on what law is, and to return to your absolute rights, to those interests of dominion, to which then give you a power over that legal estate that was created at your birth, then that might be for you. But if you're going to bring me anything that is, I don't mind going through this. I think that still, even though I'm speaking about the same things I just did, and with David Ward and Anna von Reitz, and it doesn't matter who you bring me. Essentially, these people are going to be talking of trying to navigate their property rights and their interests without comprehending what law is. If you ask them what law is, they won't know. That's what you and this course is, well, this English law series is all about, is to come to terms of what law is. And with that, I hope that I clarified it. And again, I think that anybody that embarks on challenging or investigating the system is doing a service. But to what end? And that is up to you. If you look in the mirror before you embark on anything, and this is, again, relating back to your true power, I can look at any video, anyone speaking about any terms or whatsoever of remedy. I know exactly what they're speaking to immediately. Now that same power is going to be enjoyed by you when you start to comprehend what law is, and you don't have to waste your time in volumes of books and ideas and concepts and documents. You can get back to essentially what is supposed to be, you know, of ease. It's not to be convoluted. Law is reasoning, and divinity is simplicity, and simplicity is divinity. So if we don't have that, and sure, you might think that way I express things, you're still not up to speed. But again, the terminology I use is from the law books, and if you get the gist and start looking at what the terminology is, like I do, and I still do on a lot of things that I read when it pertaining to law, I look up the words because my vocabulary is not great, nor is my command of the English language. So by looking to the legal definition of those words within the confines of those who know how to speak to the law, then I can easily ascertain what these guys are saying as I read through it without assuming. So like, subscribe, share. Let's, if we really want to get back to 100% responsibility, we have to be looking in the mirror and saying, if I'm supposed to be 100% responsible, and maybe that's something ended on here, where Mark-krishon is speaking to, he's blaming. Okay, it's the elite. It's this committee of 300. It is the cops. It is they're stealing they're stealing your labor. They are. If you're doing that, it's because you don't understand what law is. Okay, you're the only 100% responsible. You have the full power, and it's only through that individual right which can be executed, that full power, because as soon as you join a group, as soon as you say that I'm of this or I am that, you're classifying a title, and if you don't know what that title means in the constructs of either common law or equity, you're going to be, our learned judge is going to throw your ass into a constructive trust, and that's what they're going to do with this guy here as well, or anyone that services this, because it's an equitable-based remedies. So like, subscribe, share, as I just mentioned. Hope you found this video useful, and maybe help you channel your energies into commanding the full power of your individual rights, being 100% responsible, and using the law. God bless everyone, as I am God and not the God you believe in. The fun I have.